Welcome to Judicial Watch. I'm Tom Fitton, President, Judicial Watch. We're a conservative, nonpartisan educational foundation dedicated to promoting transparency, accountability, and integrity in government, politics, and the law. And through our educational activities, Judicial Watch seeks to ensure that political and judicial officials obey the law and do not abuse the powers entrusted to them by the American people. So tomorrow marks the second anniversary of the imposition of the Obamacare on the American people. And next week we will hear historic constitutional challenges to Obamacare, otherwise known as the Patient Protection and Affordable Care Act. That will occur before the Supreme Court. Obamacare is an unprecedented government power grab and is a fundamental threat to our nation's constitutional order. The challenges being heard next week by the High Court seek to vindicate federalism, individual liberty, and limited constitutional government. Many Americans, including thankfully some federal court judges, simply reject the notion that the federal government can, for example, force Americans to buy health insurance. As U.S. District Court Judge Roger Vinson wrote, who ruled against the individual mandate, it is difficult to imagine that a nation which began at least in part as a result of opposition to a British mandate giving the East India Company a monopoly and imposing a nominal tax on all tea sold in America would have set out to create a government with the power to force people to buy tea in the first place. If Congress can penalize a passive individual for failing to engage in commerce, the enumeration of powers in the Constitution would have been in vain, for it would be difficult to perceive any limitation on federal power, and we would have a Constitution in name only. Surely this is not what the Founding Fathers could have intended. A Constitution in name only. Well, the Founding Fathers didn't intend that, but a Constitution in name only is but one of the awful possible outcomes if the Constitutional Court challenges against Obamacare don't succeed. But also in the meantime, the crisis is ongoing outside of the courts. From the corruption of Obamacare's passing, remember the Cornhusker kickback, to the controversy of its implementation, which has seen a vicious attack on the church, waivers to Obama campaign supporters, and taxpayer-funded propaganda starring Andy Griffith of all people. And don't even get started on the $2 trillion in costs and the regulatory webs that are beyond comprehension. We have an excellent panel of experts here today, including former Attorney General Bill McCollum, Betsy McCaughey, President of Defend Your Healthcare, who's former Lieutenant Governor of New York, and Lee Casey, partner at Baker Hostetler. Unfortunately, due to the poor weather conditions, the fog, South Carolina Attorney General Alan Wilson will be unable to join us today. Each and every one of these panelists is a leader in the battle, and we're lucky to have their benefit of their expertise. First up, before we begin the program, be sure to turn off all your cell phones before I forget, or put them on buzz. I'm going to introduce now first Betsy McCaughey, who's a patient advocate, constitutional scholar, and as I said, former Lieutenant Governor of New York State. Her bio is in the materials you have and on our internet. And just let me say, generally speaking, Betsy has been fighting this. She fought effectively Hillary Care. She fought effectively Obamacare when it first reared its ugly head in the stimulus project. And obviously, she even made it better once it came up by calling attention to some of its worst aspects. What Betsy has done effectively is actually read the legislation and point out some of the problems with it by referring to the text in the legislation, whether it was in Hillary Care, whether it was in the stimulus package, or whether it was in the Obamacare legislation. And for that, she drives the other side crazy. And she's been one of the most effective advocates against senseless socialized medicine we have, and she probably knows more about this issue and has been involved in the public policy fights related to socialized medicine since going back before the days of Hillary Care. So with that, I turn it over to Betsy McCaughey.
Thank you.
Thank you.
Thank you. I am really glad to be here with you today. It's a historic moment as we prepare to go to the Supreme Court for a constitutional showdown against the Obama health law. And with the U.S. Constitution on our side, freedom should prevail. This Obama health law forces you to enroll in a one-size-fits-all government-designed health plan whether you want it or not, and more importantly, whether you need it or not. It also broadens the powers of the IRS to penalize you if you fail to comply. And whoever occupies the White House has the authority to dictate what your health plan must include. Nothing in the United States Constitution permits this. In addition, for the first time in history, this law empowers the federal government to dictate how doctors treat privately insured patients. So even if you're an Aetna or Cigna and you've paid for the plan yourself, the government is still in charge. The law says that you must enroll in a qualified plan. And the law says that qualified plans can pay only those doctors and hospitals that obey whatever regulations the Secretary of Health and Human Services imposes in the name of quality. Well, that can include everything in medicine. When your cardiologist recommends a stent versus a bypass, when your OBGYN decides to do a cesarean section, your doctor's decisions will be monitored for compliance with federal guidelines, and your doctor could be in the position of having to choose between doing what's best for you and staying in the government's good graces. You know, women went to the barricades to prevent the federal government from accessing their health records or dictating to their doctors. Now, many women's groups are supporting this law, which does both, accesses your health records and dictates to your doctor. How can it be that a woman is free to choose an abortion, but not a hip replacement? Either your body is free from government interference, or it isn't. The president promised that he would make health insurance affordable in order to help solve the problem of the uninsured. But that's not what this law does. You've gotten your premium hikes in the mail. Instead, this law vastly expands Medicaid. According to the administration's own projections, nearly 1/3 of Americans under age 65 will be on Medicaid, moving this nation toward a Medicaid nation. Customarily, states have made the decisions about eligibility and benefits under Medicaid, but this law puts the feds in control and coerces a 57% increase in enrollment in Medicaid in Texas, 42% increase in Medicaid enrollment in Virginia, for example. Medicaid expansion may be the sleeper issue in this Supreme Court showdown. All the lower courts rejected the Medicaid challenge, but the Supremes saw fit to give it a second look. Under this law, Medicaid spending will increase from $343 billion in the last year of the Bush administration to $900 billion before the end of the decade. How will this enormous increase in Medicaid spending be paid for? Well, there's $503 billion in new taxes and fees right here in this law. And already in Washington, they're talking about another new tax, the VAT, the Vanishing America tax. Oh, yes. But in addition, this vast expansion of Medicaid is paid for by eviscerating Medicare. The law takes $575 billion out of future Medicare funding over this current decade and shifts it over to pay for the new entitlements under the Obama health law, particularly the expansion of Medicaid. Richard Foster, the chief actuary of Medicare and Medicaid, told Congress on April 22, 2010, that the cuts to hospitals, the cuts to what hospitals are paid to care for seniors, would be so severe under this law that 15% of hospitals would be forced to operate in the red, and other hospitals might have to simply stop taking Medicare altogether. Where will seniors go if their hospital stops taking Medicare? To make further cuts, this law creates the Independent Payment Advisory Board, 15 unelected, unaccountable czars. The IPAB board is charged with further reducing Medicare spending. In a radical departure from Medicare as we know it, Congress cedes its budget-making authority over Medicare to this unelected board. The law says that IPAB cannot reduce Medicare benefits, but those are weasel words, because in fact, IPAB can reduce the reimbursement to caregivers so low, lower and lower and lower, until no one can afford to do a hip replacement anymore. To halt this attack on our constitutional principles, our liberty, and our health care, 28 states and numerous other parties have challenged the constitutionality of this law. And next week, 26 of those states will get their day in court, or I should say their 3 days in court, an unprecedented 3 days of oral argument. The High Court's decision on the individual mandate may turn on one astounding fact, and that fact is this: half of Americans consume virtually no health care. That's an exact quote from a federal agency, the Agency for Health Care Quality and Research. Research and quality. Yes, half of Americans consume virtually no health care. The 11th Circuit Court of Appeals was the only court to directly reject the administration's false claim that health care needs are universal and inevitable. The 11th Circuit was also the only court of appeals to overturn the individual mandate. The Obama lawyers argue that all Americans need health care, all Americans are therefore in the health care marketplace, engaged in health care commerce, and therefore all Americans are subject to Congress's power under the Commerce Clause. Congress has the authority to require that they pay for their health care with insurance. Wrong, said Judges Hull and Dubina, the bipartisan team in the 11th Circuit that struck down that mandate. Wrong, they said. The mandate is over-inclusive because it applies to people who are healthy and don't need health care and may not need any health care for years to come. Those two judges had the facts on their side. The Agency for Healthcare Research and Quality issued a new report, January 2012, confirming their earlier findings that virtually half of Americans consume no health care. And when you look at the under age 65 group, to which the mandate would apply, it's even way over 50% who consume no health care. Half of the population needs only 2.9% of the health care consumed in this country, an average of $238 a year, and many of them consume zero health care in a year after year after year. The 11th Circuit Court of Appeals demolished the Obama administration's Commerce Clause argument. And to underscore how unprecedented it was for Congress to attempt to require that Americans purchase a product, they recalled in 1968 when Congress passed the Flood Insurance Act to try to incentivize Americans who lived in floodplains to buy flood insurance. They never considered requiring them to purchase it. But now the Obama administration wants to require all Americans, including healthy Americans, to buy the mandatory health insurance plan. That would be like requiring Americans who live on tops of hills to buy health insurance. So that one pivotal fact, that virtually half of Americans need no health care at all, shows that the Obama administration's Commerce Clause argument is a flim-flam. Let's hope the Supremes agree with this reasoning and recognize the facts. But if they don't, there are several other challenges on the way. Number one, can the federal government dictate how doctors treat privately insured patients. In 2008, the Supreme Court ruled no when the Bush administration attempted to dictate how doctors in one state treated patients in one particular circumstance. No, the court said, it would entail a radical shift of authority from the states to the federal government and literally a standardization of medicine in all locations in the country, something the Constitution does not permit. Secondly, privacy groups are challenging the impact of the mandatory electronic medical records, which create a tell-all relationship with every doctor you see. Have an abortion, your foot doctor will know. See a psychiatrist, your orthopedist finds out. Religious groups, thirdly, will be challenging Section 1302, which empowers the Secretary of Health and Human Services to dictate what your health plan must cover, even if it interferes with your practice of religion. And fourthly, of course, those provisions of the Independent Payment Advisory Board will be challenged. The over-delegation of congressional authority to an independent board, and that bizarre provision that IPAB can only be repealed in a little tiny window between January 1st and February 1st, 2017. Any Congress can supersede the work of a previous Congress. So in conclusion, let me say that the authors of the Obama health law disrespected all of us. They didn't trust the public to choose their own insurance plans. They didn't trust doctors to treat their patients properly. They didn't trust states to make good decisions about Medicaid based on what their own taxpayers and budgets could handle. And they didn't even trust future Congresses to reflect the true will of the American people. Instead, they accumulated all power in the executive branch in defiance of the principles of our nation, the founding principles of our nation. But fortunately, those principles will be right by our side next week as we do battle in the United States Supreme Court. And with the Constitution on our side, freedom will prevail. Thank you.
Thank you, Betsy. Another leader in this fight is Bill McCollum, who served as in the House of Representatives for 20 years or so as a stalwart conservative leader, usually fighting his own party sometimes on some of these issues that conservatives care about, but being an effective conservative spokesman to the media as well and a leader in that regard. After that, he ended up as Attorney General of Florida, and in that capacity, he led the charge against Obamacare legally. And I recall when the lawsuits were filed, and you initially you filed the lawsuit the day after Obamacare was signed, and he was ridiculed and attacked, again by some of our friends, but obviously our enemies, but he thought this needs to be challenged, and his innovative lawsuit, not only as it relates to the individual mandate, but to the federalism issues that Betsy talked about with respect to Medicaid, are now before the Supreme Court, and he proved all the naysayers wrong. So we're proud to have here, he's now partnered with SNR, Denton's public policy and regulation practice, former Attorney General Bill McCollum.
Thank you for that nice introduction, and it's exciting to be here. First of all, Judicial Watch is one of my favorite organizations, and you've been doing the challenging things for the conservative cause for a long time, and I'm just thrilled to be here. We're all greatly appreciative of that, and those of us involved. I also am happy to be here with Betsy because I know the work she's done. She and I have encountered each other on other occasions. It's delightful to be on the same program with you. And he doesn't get as much attention as his partner in these articles, David Rifkin. But Lee Casey, I was with Baker and Hostetler at one point not too long ago, before I became Attorney General, and to have seen that article that I did, that you and David wrote, and your name's always there with his. I know you're doing the work over there, at least a lot of it. And to see that article, which I did, I think, in September of 2009 about the individual mandate, is what inspired me to send our team off to do some research at the Attorney General's office, and then ultimately to file this lawsuit, which, Tom, actually was filed within 10 minutes on the day the President signed this into law, of when he signed it. So that is a great team to be up here with. I want to do 2 or 3 things very quickly, because I want to try to stay within about 6 or 7 minutes as requested. I think the most fun of this is going to be you asking questions or our engaging in discussion. And I do want to hear what Lee has to say because of his background. Let me give you an overall comment, putting in context my views about the big picture bill, and then the rest of it's on the lawsuit. I agree with Betsy about the problems with this bill, but I think what's being missed in a lot of the debate over health care reform, as we call it, is that America has the greatest health care delivery system in the world. And we have been very fortunate with the innovation and the research and all the other things that have happened. And it may take 3 or 4 or 5 years, but everybody, regardless of income, regardless of status, has been and is a beneficiary of this. We're in a very destructive mode at the moment, and this particular bill is very destructive. There are 3 pillars to quality health care, 3 pillars to a really good health care system: quality, accessibility, and affordability. And I don't get any argument on that, whether it's a liberal or conservative or anybody else who I'm sitting on a panel with talking about what are the basic principles of what make up a very good health care system. And what is wrong, though, with this particular legislation, the Affordable Care Act, is that it undermines and it hurts all 3, quality, accessibility, and affordability. So in discussions later, if you want to go down that road, separate and apart from the merits of this lawsuit, I'd be happy to help engage along with the others in that kind of discussion. The lawsuit itself has several interesting discussions that will take place next week, which is why we're really here today, Tom, as I understand it, to prelude the Supreme Court arguments, the oral arguments. And, of course, the decision will occur presumably near the end of June. The first day, they're going to focus on what's called the Anti-Injunction Act. For most of us, that's very technical. It is very important. It is being argued by an outside group that the Supreme Court asked to come in and do this, that because of a couple of lower court decisions, not ours, but in another case or two, that this is somehow a jurisdictional issue, and that the penalty, what we call the penalty in here for the individual mandate, is actually a tax, or it comes so close to being one it's going to be interpreted to fall within the ambit of the so-called anti-injunction law. And without getting into great detail, the Anti-Injunction Act provides that if you are a taxpayer challenging a tax law, you can't do that until the law becomes effective, until you pay the tax, and then you basically are seeking a refund. And then you say, hey, it's not constitutional, I need my money back, or whatever. It is a very difficult thing for me to see that at the end of the day, the Supreme Court is going to say, we're going to not hear this case, put it off for a couple of years. Wouldn't be the end of it on the mandate, but it's not ripe, in essence, not ready. You've got to wait until 2014, and then probably 2015 is a practical matter. But there are, going to be plenty of those who argue for it. There are a couple of judges whom I respect who've ruled this way. So you have to watch it. You have to respect it. Politically, if the judges wanted to do that, by the way, the Justice Department doesn't want to postpone this. The states don't want to postpone it. The court's listening to the jurisdictional issue. But if they politically wanted to just kick the ball down the road, that would be a way to kick part of it down the road. It would not, even if they ruled adversely and said you got to wait for whatever reason under that act, you would only wait on the individual mandate. The Medicaid provisions still they have to decide. So I really don't think they're going to go that way. I'm not going to get in the weeds in the talk about the anti-injunction. Maybe Lee wants to address some of that, but I understand it, and I'd be happy to